Good evening. I'm David Ferriero, the Archivist of the United States, and it's a pleasure to welcome you this evening to the William G. McGowan Theater here at the National Archives for tonight's examination of the 13th Amendment upon its 150th anniversary. We're very glad that you could be with us, whether you're here in the theater or joining us on our YouTube channel. I want to take this opportunity to acknowledge our partners for tonight's program, the Constitutional Accountability Center and the National Constitution Center, and thank them for their support. Before we get to this discussion tonight, I'd like to tell you about two programs coming up in the next few weeks here at the National Archives. On Wednesday, December 9th at noon, author Andrew Jampilar will be here to talk about his new book, Embassy to the Eastern Courts, America's Secret First Pivot Towards Asia, 1832 to 1837, which chronicles a secret mission to negotiate with Eastern potentates during Andrew Jackson's presidency. And next month, on Friday, January 15th at noon, we'll present two films from our motion picture holdings in honor of the 75th anniversary of the Tuskegee Airmen, Wings for This Man and The Negro Soldier. To learn more about these and all of our programs and exhibits, consult our monthly calendar of events in print or online. There are copies in the lobby, as well as a sign-up sheet where you can receive it by regular mail or email. Tonight, we examine the 13th Amendment to the Constitution, which put an end to slavery in the United States. Interestingly, although the Constitution, as passed in 1787, sanctioned slavery, notably with the section on the slave trade, the 3/5 clause, and fugitive slave clause, the word slavery did not appear in the document until the 13th Amendment. In this building, we hold the joint congressional resolution proposing the amendment to the states, the certification that the amendment had been ratified in 1865, and the ratification instruments passed by the states. One of these, California's, is on display upstairs just outside the rotunda. Among the congressional resolutions proposing constitutional amendments is one that could have been the 13th Amendment. This earlier amendment, proposed to the states in 1861, would have prevented Congress from passing any laws interfering with the existence of slavery. One can trace the legacy of the 13th Amendment through our records, with the 14th and 15th Amendments, the Civil Rights Act, the Voting Rights Act, Supreme Court decisions on civil rights, and much, much more. Within the National Archives, we preserve important high-level documents such as these, but we also contain records created on a more personal level. Through the Freedmen's Bureau records, pension affidavits, and court testimony, we hear the voices of those who lived through trying times and struggled to gain the rights guaranteed to every American citizen. Great and small, these records are our national legacy, and it's a great honor to preserve them here at the National Archives. Now it's my pleasure to welcome Judith E. Schaefer to the stage. Judith is acting president of Constitutional Accountability Center. And before joining the center, she served as the legal director for People for the American Way. Previously, she was a partner at Dickinson, Shapiro, and Morin, and a law clerk for Chief Judge Joseph S. Lord III of the United States District Court in Pennsylvania. Judith is a recipient of the Lamba Legal Defense and Education Fund Attorney Appreciation Award, the Whitman Walker Clinic Jean Frey Memorial Award for Community Service, and the Women's Legal Defense Fund Volunteer Attorney Award. Please welcome Judith Schaefer.
David, thank you so much for that very gracious introduction. Welcome, everybody. Good evening. On behalf of Constitutional Accountability Center, I want to thank you very much for joining us tonight for what is going to be a very exciting discussion about the 13th Amendment and the continuing importance of all three of the transformative Reconstruction amendments. Before we begin, I'd like to thank the National Constitution Center. Let me thank the National Archives first, and their terrific staff for their support for this event. I can't think of a better place to celebrate and discuss our Constitution than the building where it resides, upstairs, as David just said. I also want to thank the National Constitution Center and their president, Jeffrey Rosen, for partnering with Constitutional Accountability Center in a 5-year celebration of the 150th anniversaries of the Reconstruction Amendments, a celebration that we call the Second Founding Project. I'll explain that title in a moment. Let me also thank the National Endowment for the Humanities, which has been so supportive of our Second Founding Project. And I want to recognize their deputy chair, Peggy Plimpton, who is here tonight. Peggy, thank you so much for joining us. Finally, I want to extend our deep gratitude to all of our panelists, our outstanding panelists, for taking the time to be here and to share their opinions and their expertise. So why are we here on this particular Monday in December? We're here because yesterday, December 6th, was the 150th anniversary of the ratification of the 13th Amendment in 1865, the first of 3 amendments secured by President Lincoln's generation in the 5 years following the Civil War. These amendments, the 13th, 14th, and 15th, so fundamentally transformed our Constitution that many scholars appropriately describe them as our nation's second founding. These amendments ended slavery, guaranteed equality and citizenship, expanded the right to vote, prohibited racial discrimination in voting, and ensured that the national government has the power necessary to secure civil rights. In short, the Reconstruction Amendments gave our nation what President Lincoln promised at Gettysburg, a new birth of freedom, enshrining in a central place in our constitutional order the self-evident truths about equality and liberty set out in the Declaration of Independence. Nearly 3 decades ago, America came together to celebrate the bicentennial of the 1787 Constitution. As the second founding turns 150, we are working with our partners at the National Constitution Center, our honorary chair, Justice Sandra Day O'Connor, leading scholars, and a growing list of organizations like the National Endowment for the Humanities to build a 5-year celebration that is worthy of the constitutional achievements of President Lincoln and his generation. The Second Founding Project was the brainchild of Doug Kendall, Constitutional Accountability Center's founder and president. Doug recognized that most Americans know very little about the Reconstruction Amendments and the critical role that they played in our country's history and continue to play today. Doug was determined to change this, to help educate Americans about the Reconstruction Amendments and about their vital importance today, to celebrate them and to see to it that these 3 amendments receive the public recognition and place of prominence in our national consciousness that they so deserve. Doug knew that the series of 150th anniversaries coming up over these next 5 years would provide the perfect opportunity for education, discussion, and celebration. Indeed, on Friday, the White House issued a proclamation marking the anniversary of the 13th Amendment, explaining its transformative importance and calling on the people of the United States to observe the day with appropriate programs, ceremonies, and activities. Very sadly, Doug passed away in September at far too young an age. But Doug's work lives on through the Second Founding Project and everything else that we at Constitutional Accountability Center do every day to promote the progressive promise of the Constitution's text and history. This evening is a celebration of Doug's vision as well as of the 13th Amendment. I know that Doug absolutely would have loved tonight's discussions. Let me now turn things over to Jeff Rosen, president of the National Constitution Center, and our wonderful moderator for both of tonight's panels. And thank you all for joining us this evening.
And let me welcome our panelists who will come up properly. Judge. Ladies and gentlemen, seeing Doug Kendall's behind us made me recall the day 2 years ago, soon after he realized that he was ill, when he conceived of this Second Founding Project. And Doug Kendall was a visionary, and he believed that it was important in these polarized times to educate all Americans about the history and contemporary meaning of the Reconstruction Amendments. He believed that too little is known about them, and he came up with the idea of creating a National Advisory Board chaired by Justice O'Connor to bring the best thinkers in America, liberal and conservative and everyone in between, to unite around these three charters of freedom that all of us share as Americans. He realized that we may disagree about their contemporary meaning, but we are bound in unity, in union, that crucial word that Lincoln used so much, by the notion that this was the crowning constitutional achievement of the Civil War. And he, with his breadth of vision, conceived of a 5-year initiative where we would use these anniversaries to hold events just like this to educate citizens about their constitutional history. And he would be smiling, because here we are at the National Archives, the day after ratification, with this extraordinary group of panelists. You have two panels of the finest judges and thinkers in America about the 13th Amendment. He would be proud of us, and I'm so glad that we're here. I want to jump right in. Let me just do what Doug always expected me to do, which is to recite the Congressional Charter of the National Constitution Center. For those of you who haven't heard me do this before, the National Constitution Center is a beautiful nonprofit on Independence Mall in Philadelphia, right across from Independence Hall, with the most beautiful constitutional views in America. And it was created during the bicentennial of the Constitution to disseminate information about the US Constitution on a nonpartisan basis. And that is what we do every day and in every media platform, creating the best interactive constitution on the web that's united the finest liberal and conservative scholars to write about every clause of the Constitution, describing what they agree about and what they disagree about. And you can read about the Reconstruction Amendments there. We have panels and symposia like this one and this beautiful museum of We the People that has a copy of the 13th Amendment signed by Abraham Lincoln and loaned to us by David Rubenstein. So we're just thrilled by this partnership and are looking forward to a phenomenal series of discussions over the next 5 years. Let me briefly introduce these magnificent panelists because you're in for a treat in this discussion. Starting from my right, Judge Jeremy Fogel is currently the director of the Federal Judicial Center in Washington, D.C. He's a senior judge for the U.S. District Court for the Northern District of California, and he just presided over, at the National Constitution Center, the most spectacular 2-day symposium about the history and contemporary meaning of Reconstruction, which united about 30 federal appellate judges and district judges in the country, including Judge Donald. And we'll talk more about it, but it was one of the most meaningful and intense and moving experiences that I've ever had. So thank you, Jeremy, for doing that. The great Sherrilyn Ifill is currently the 7th president and director counsel of the NAACP Legal Defense and Education Fund. Her predecessors include Charles Hamilton Houston and Thurgood Marshall. It is a pretty distinguished group.
No pressure.
No pressure at all. And we were absolutely thrilled that Sherrilyn recently agreed to join the board of the National Constitution Center. We're thrilled to have her in the family and very glad that she's here. The great Judge Wynn, you came up with the idea of having this panel in particular. You said, you know, we had the Second Founding Initiative going, but you said we got to do it right the day after ratification. We'll do it at the archives. And I said, yes, we've got this initiative. And you just had the vision of bringing us together. He is a judge on the U.S. Court of Appeals for the 4th Circuit. And he, among his many distinctions, well, I think it's really cool that you served in the U.S. Navy JAG Corps as a captain. And Judge Donald, who I was so lucky to be able to spend time with in Philadelphia just a few weeks ago, is currently a judge on the U.S. Court of Appeals for the 6th Circuit. She was the first female African-American judge in the history of Tennessee, and she was confirmed in 2010. All right, Judge Wynn, because you brought us here in some sense, I do have to read the amendment because we're going to be talking a lot about it. So let's remind ourselves what it says. I can either scroll down or I can go to this thrilling National Constitution Center pocket constitution with an absolutely riveting introduction by yours truly and David Rubenstein about the founding documents. The only problem is that I can't read it anymore unless I hold it far away. But here it goes. You know it by heart, I'm sure, and I should, but here it is. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And then section 2 says, Congress shall have power to enforce this article by appropriate legislation. Judge Wynn, why is that text important, and why is it meaningful for Americans to learn about it and celebrate it?
Thank you, Jeff. And I gotta say thank you, Jeff and Judy and Dave, for attaching the level of significance to this time period for the 13th Amendment. Two reasons. The first reason being it is without question the most important date in African American history by definition. The abolition of slavery has to be the most important date in African American history, and it most assuredly happened on December 6, 1865. The second reason is the basic rule of law and the force of law of what it has in our society. That it was not through a proclamation, it wasn't through celebration, it wasn't through individual emancipations, but only by changing the sovereign will of the people can you change the law of a nation. When we go to other nations, we try to have them to follow the rule of law. And by following the rule of law, we change, in the words of Hamilton Houston, in the words of von Euren from Germany, from Roscoe Pound, to Thurgood Marshall, up to the Brown versus Board of Education decision, we change society, and if you will, the term that some thinks pejorative is sociological engineering, and this is not it, but it essentially says to change the laws and the habits of a world and of the nation, you change the law. That's an appreciation that law students need to have, lawyers, and all legal types on a micro level in our nation. So it just has tremendous significance beyond our religious beliefs, our moral beliefs, or whatever. That changing the Constitution is how you change the character and you change the social mores of a nation.
Beautiful. Judge Donald, would you add anything to that? Why is the 13th Amendment significant? And was it significant just by itself, or was it also important to have the 14th and 15th Amendments to fulfill the promise of the Civil War?
Thank you so much. I am so delighted to be here with this esteemed panel, and thank you for the question. I think it has significance that really extends far beyond that. I want you to think about the words of Lincoln, who said that no nation can stand half slave and half free. I want you to think about the eloquent founding documents that talk about freedom, men and women being created equal. Those ideals cannot really stand alongside a nation that enslaves its people. And at some point, we as a nation, I think, had to live up to those founding documents. And I recognize that we're still in that struggle. You read the words of the 13th Amendment. It is critical to think, when you look at those words, one of the things you do not see or hear in those words is any mention of the word equality. So while we had the abolition of slavery, that was not an end of itself. The 14th was necessary because that came back to talk about equality. You can have abolition, and that was an important step. It was crucial, as Judge Wynn said. But that alone doesn't do it, because you have a people who have been subjugated, who have been enslaved for a couple of centuries. And it's important to abolish. But then what? Because one of the things that the Congress and others were concerned about, well, even if we do this, does this mean that those black people, those former slaves, are all of a sudden going to be able to consider themselves equal to whites? And that was something that people had to sort of get their heads wrapped around. But the 14th Amendment came back and spoke to equality and to justice. And so I think that the 13th, 14th, and 15th are important, but they were necessary to move us along that road to ultimate equality.
Wonderful. Judge Fogel, so much happened at that incredible symposium that you created, and all kudos to you for bringing that great group together. But focusing on the history, what did you learn? What surprised you most about the discussions? What did you learn about the 13th Amendment, and what do you want to share with the audience?
Well, I want to join everyone else and say how happy I am to be here and what an honor it is to be here and to be with this group on stage. I learned in preparing for the program in Philadelphia, I did a lot of study of Reconstruction. And learned that so much of what happened was something I had never been taught. You know, that our collective history as a country, you know, you might have learned there was sort of an Orthodox history for a while that, you know, there were carpetbaggers and scalawags going into the South and exploiting the poor Southerners. And, you know, it was, we didn't learn about what actually happened. And I think getting prepared for that, and I don't mean to slight that there were people who suffered in the South too, because there were. It was just getting a better sense of that history. I think that was one of the most important things for me. But then you have these aspirations, and Judge Donald summarized them so well, that you abolish slavery, that you try to ensure equal protection of the laws, you try to ensure voting rights. And this all happened 150 or so years ago. And then you look at what actually happened. And those goals were aspirational then, and they're aspirational now. And so what came out in the conversation, and we had, as Jeff said, we had 30-odd judges there, and we were very deliberate in inviting people from all different backgrounds. We really strove for diversity of every conceivable kind. And what we found was that people had very different life experiences, and that they really didn't know much about each other's life experience. You know, sure, we all want to be equal, we all want to respect the law, but the real quality of what it's like to grow up in this way or that way, and the differences that growing up this way or that way have, though the effect that those differences have on us was just really very profound, and we don't talk about it. You know, we still are separate in some way, unless we're fortunate enough to have friends who really open up to us. It's not, we don't really know. And I'll just give, if I might, just two really simple examples. There were a number of judges in the group, very accomplished people, they're national leaders in the judiciary, who went to segregated schools and were old enough to remember that experience, and they talked about it. There were people who, Caucasian judges who were serving in the South when the University of Mississippi was integrated, when the Birmingham church bombing took place. And they talked about their experience as human beings with these events. And we don't do this enough. We don't even begin to do this enough. So I think that's what I learned as a result of the program.
That was.
If I could just make
of
just
course.
one comment, because I think Jeremy is absolutely correct. Because we tend to think, oh, this is history, and it was such a long time ago. But as you mentioned, as you observed, that many of us who are still here right now, that's part of our lived experience. So it also speaks to recency, and we want to say that, oh, that it was then, this is now, but it's all threaded together.
I'm so struck by the same thing that both of you were, and as Judge Fogel said, hearing the judges talk about what it was like for them. One judge had a relative who was a slave, and then was talking about applying the law and being in a courtroom with all white jurors, and his efforts to diversify the pool and the difficulty of doing that. It was very, very important to share those experiences, and was absolutely unforgettable. Sherilyn, Judge Fogel mentioned the gap between the promise of the amendments and their reality. And you, in an essay called Freedom Still Awaits, said very eloquently, neither the enduring power of the second founding nor its limitations can be fully understood without an examination of the third founding, the civil rights movement of the mid-20th century. Of course, it was the NAACP Legal Defense and Education Fund played such a crucial role in the crown jewel of that third founding, the Brown versus Board of Education decision. But how did the third founding fulfill the promises and inadequacies of the second?
Thank you, Jeff. And I, too, am just thrilled about this project, thrilled to be here with all of you, and actually just incredibly moved by what you just said, Judge Fogel, because one of the things you're aware of as a civil rights litigator is that you are appearing before judges who very often do not know this history and really don't know about this chasm that you're describing. At the outset, there was this remark about how the original Constitution did not mention the word slavery, right? It was about the importation and migration of persons. There was all of this delicacy, very deliberate delicacy because there was an understanding that the word slavery did not go with all of the other high-minded principles that were in the document. So the second founding is a moment when America has to confront itself, and that it is pushed to that moment after awful years of war and bloodshed and decimation. But it is compelled to confront itself, and it now has to use the word in that document that the founders, the original founders, who actually most people learn quite a bit about, did not have the courage to use. So it's an important moment of America growing up and having to confront what it had kicked down the road, right? The slavery can was kicked down the road with the original Constitution, the delicate language, the 3/5 compromise, all of the ways in which the issue of slavery was managed around in that original Constitution, not to confront this immoral core in the founding of our nation. So you have the confrontation of the language, you have the 13th, 14th, and 15th Amendments, which really do have to be read together because freeing the slaves was not enough. As a matter of fact, the history is quite clear that most in the South, most leaders in the South, white leaders in the South, hoped that even freedom would not mean like the whole Megillah, would not mean that blacks were going to vote, would not mean that blacks would have property rights, would not mean, there was still, hope sprung eternal, that there was still a way to manage newly freed slaves as slaves without the formal title. So they do have to be read of a piece. But the truth is that even those 3 amendments, as monumental as they are, and we could talk about the language, of those amendments and what makes them so important. I happen to think the enforcement clauses are just kind of the most revolutionary and powerful part of the amendments. But they are not. It's not realized really until we get to the 3rd founding, because we know that after Reconstruction, when we had this opportunity and this a really great chance for America to be what it should have been, we ended up with a backlash and with redemption, and really beginning in the late 1870s, but certainly by the 1880s when the Supreme Court decides the civil rights cases, certainly by Plessy versus Ferguson, it's pretty much a wrap. And in fact, African Americans, certainly in the South, have been essentially returned to a condition of slavery, largely through sharecropping. They do not have the rights of free men, even though they are technically free. And the 3rd founding is different than the 2nd founding. It doesn't require a formal war, but it does require the people to rise up and to give meaning to the words in the amendments of the 2nd founding. And so it is once again a moment of confrontation. I mean, right now I hear people talk about nostalgia for the 1950s. Oh, America, if it could be just as great as it once was. Well, there were many great things about America in the 1940s, many great things about America in the 1950s, but there were many not great things about America in the 1950s. And if you're a black person and you hear that, you're thinking, well, who would I have been in that period? Where would I have been? Who would my children have been? That's what I'm just letting you know. That's what we're thinking when we hear people say that. So it was yet again a moment of confrontation. And one of the most poignant of those moments occurred in Selma, Alabama with Bloody Sunday, when activists marched on the Edmund Pettus Bridge and were beaten. And CBS News, the network, interrupted their showing of Judgment at Nuremberg, right? So America's watching for the first time the broadcast of this film about the war crimes tribunals after World War II, and they interrupt, and all of America gets to see this violence that's happening. That African Americans have been living with for decades. So it's yet another moment of confrontation and maturation for the country, and what comes out of it are a whole series of civil rights statutes that could only be created because of the enforcement clauses of the 13th, 14th, and 15th Amendment.
That is beautifully said. And Judge, I want you to react to that, Judge. And it's a pretty powerful claim Charlene has made. She says that the 2nd founding was really subverted by the courts and by political resistance. It took the 3rd founding to fulfill some of its promise. You wrote an article for a bar journal in North Carolina about the contributions of Charles Hamilton Houston, who was special counsel for the NAACP. You called him a great social engineer, favoring more methodical approach at the state and federal levels. Talk about him, about the 2nd founding, and tell us straight, what was its achievement? How did it overcome the failings of the second.
You know, Jeremy, I could talk all day long about Charles Hamilton Houston, the second and third founding, but I want to focus on the 13th Amendment.
Okay, you can do that too.
That's really what I want to talk about, because this is where these discussions go.
All right,
I get
good.
all kinds of discussions about what's going on now, but you don't focus on the historicity of the 13th Amendment. And I will tell you, Jeremy, you're not the only one that know nothing about this amendment. You could walk into any major African-American group, any function, and ask them, what is the date on which African-American slaves were freed, and they couldn't tell you. I mean, they would look dumbfounded. And you know why? Because we as Americans have been intentional in creating what I say obituary history. You tell the good stuff and you leave all the other stuff out. You don't tell stuff like there were laws that prohibited African Americans or freedmen and others from even preaching to slaves. There were laws that prohibited, and when I say prohibited, I mean you got lashes for anywhere from 20 to 39 lashes on your back for preaching to a slave, whether you were free or not. Bareback. And that's true whether you taught them to read or write. That's not in your books. And so when you get down to the fact that the Emancipation Proclamation from a legal, how does a law student not know that an executive order or proclamation is not law? How do you go around and teach that, even with the war powers? How do you not understand what property rights means in the Constitution, that any Supreme Court will come back and say, no president can take away a property right? I mean, those are the kinds of fundamental things that we are missing when we talk about the significance of the 13th Amendment. And I would love to talk about Charles Hamilton Houston. As I told you, I can take you from Barn Euban all the way to Thurgood and all of it, but that's another discussion.
Good.
The 13th Amendment is what we ought to focus on.
Great. I love your focus on the text, and you're forcing me to be a good law professor. So that means the rest of the panel, let's talk about the 13th Amendment, and let's teach ourselves and our great audience about the details. So I'm going to read from the joint statement of the Interactive Constitution of the National Constitution Center. This is Jamal Green and Jennifer Mason McAward, nominated by the Federalist Society and the American Constitution Society. The leading conservative and liberal lawyers groups came up with this joint statement, so they agree on every word that I'm about to read. And they say, the most immediate impact of the 13th Amendment was to end chattel slavery as it was practiced in the southern United States. However, the amendment also bars involuntary servitude, which covers a broader range of labor arrangements where a person is forced to work by the use or threatened use of physical or legal coercion. For example, the 13th Amendment bans peonage when a person is compelled to work off a debt. Now I'm in law professor mode and I'm calling on people, but you can dodge the question. Judge, tell us, so it's, Sherilyn said the enforcement clause is the most important. It bans not only slavery, but also peonage. And then it was interpreted in the 1960s to ban some private discrimination, even though in the civil rights cases, the Supreme Court said it didn't ban private discrimination. So tell us what, in addition to slavery, the 13th Amendment bans.
Well, going back to the text, the courts had to actually look at what this slavery meant, and once you abolish that, what are all of the other badges that actually attach or appertain thereto? I think it was really important to look at things like your public accommodations, your restaurants that affect interstate commerce. If many of you probably don't know this, and I'm going to tell a quick story as Jeremy did earlier. I grew up in the South, even though the Brown case, and I know we're dealing with 14th now, and Judge Wynn wants to deal with 13th, but I have to tell you this.
He's going to be tough, too.
I know. So I was unborn when the first of the Brown cases was filed. I was 3 years old, don't do math, please, when the court decided the case, and 4 years old when they did the remedies phase. Yet when I began school in 1956, I started school in a 2-room cinder block school. It was supposed to be separate but equal, a Plessy kind of school, with no indoor plumbing, no running water. All of the books that I studied from came to the black school from the white school up the street. And so, the Supreme Court, the supreme law of the land, had decreed that separate but equal is inherently unequal. And of course, I knew that as a part of my lived experience. It was not until 1959 that the state of Mississippi then constructed a Plessy-compliant school, a school for the black kids with running water. It was not until 1966, after some of these civil rights statutes, that Mississippi finally, under compulsion from the federal government, said, okay, we will desegregate, but we can't do it all at once. So it's important that the courts give force and effect and interpret those laws broadly to ensure the fundamental rights that the laws were designed to effectuate. And that is equality in all sense. There are people that you talk to now who lived during the time when they could not go into restaurants and eat a meal, even though they had to pay. When I graduated high school, there were still schools and other institutions that had, not schools, but establishments that had white-only signs. The doctor there, they were totally segregated. A black person could go to the doctor, to the white doctors in our community, 7 o'clock in the morning, be the first one there, but you could not get waited on until every white person, no matter what time they came, had been served. There were an awful lot of babies born in the waiting room because there was no service for the African Americans until all whites had been served. Those kind of things, you can't have abolition and say that it's been fully effectuated when you still have practices like that, even though it's not being done under color of law, color of state law, but it's still affecting people in that fundamental way, which tells you that you are less than and equal when you're having to endure that.
But Jeff, I just want to, I mean, because we're jumping to the 14th Amendment and
Yes.
talking about equality, the word that animates the 13th Amendment is, what does it mean to be free?
Yes.
And there was some controversy about what is caught up in the bundle of being free, right? So one is that you are no longer a slave, but what does it mean to be a free person? And it was very clear that there was some difference of opinion about
Absolutely.
what were the bundle of things associated with freedom. And so part of the Civil Rights Act of 1866 was trying to explain what freedom meant in the context of the 13th Amendment, and to really ensure that newly freed slaves had the ability to live and exist as free people. I was reading some time ago some of the legislative history, and there was one legislator from Illinois who talked about all of the things that he thought was part of the bundle of being free, that he thought it was the right to contract, that it was the right for African Americans to travel to and fro and to be free from molestation, to be able to work and receive wages and so forth. And he believed that the enforcement clause of the 13th Amendment, which gave Congress the right to ensure that there was whatever legislation was necessary to effectuate the text of the 13th Amendment, that was designed to make sure that Congress could enact whatever statutes they needed to make sure that newly freed slaves could do all of those things that are associated with the bundle of freedom. Now, later we came to have and continue to have the same controversy about what the words equality mean,
Right.
or what the words due process mean. But freedom also was controversial.
And we have to wrap up in a sec, Jeremy, but maybe why don't you begin to tell us what are the range of debates about what freedom means under the Enforcement Clause today? Congress invoked it to justify the Matthew Shepard hate crimes law in 2009, and the Supreme Court said in the 60s that it banned discrimination in the sale of private property. So what kind of things are people arguing Congress can ban today?
So we're still arguing, I think, about what it means to be free. I mean, I think we're still having that. The history is that the other part of it, no slavery or involuntary servitude except for conviction of the involuntary servitude because of conviction of a crime. There's a whole story there. We could have a seminar about that, and we don't need to talk about the debate about incarceration today. We can talk about what happened after the Civil War, and a lot of the states that had been in the Confederacy passed anti-vagrancy laws. People got convicted of vagrancy, and then they were sentenced to work on the plantations. And so this is part of our history, and it's a part of our history that's not told very often. What Bernie said about the badges of slavery. I mean, I think the thing that I learned from really getting into this was that we passed these amendments, and it was essential that we did, and it was a great thing that we did. But the country, from a social standpoint, wasn't nearly ready for them. That they weren't really ready to embrace an idea of complete equality, complete equality under the law, complete equality in social life, complete equality in voting, complete equality in the right to freedom. And I think we're still fighting those battles. And I think we're trying to figure out, so what does this mean? What is yeah.
it possible?
Yeah.
I mean, one of my theories is that actually it was the courts that were not quite ready to do their role in the project.
Some
Because
of both.
the countries,
Yeah.
the average people are never ready for monumental change. But when you have a constitutional amendment, which essentially says this is who we are and this is what we stand for, whether it's ending slavery or prohibition, the people follow, right? But the role of the courts did not emerge until that third founding.
That's right.
I mean, it didn't emerge not because it couldn't have happened, because the courts abdicated that responsibility.
Well,
they did it in the civil rights cases, and they did it in U.S. versus Cruikshank. They abdicated the role that they could have played to give the true meaning and power to the 13th Amendment and to the 14th and 15th.
But they did take a role, Charlotte, and it was intentional. What the courts did was restrict the 13th Amendment.
Absolutely.
It was
Absolutely.
intentional.
No,
Don't
I
think
agree.
they
I
weren't
agree.
fulfilling their role in the process of it. And when you think about that, there were states, North Carolina in particular. The reason they decided to ratify it on December 4th, just 2 days before, is because they had the notion that if we ratify this 13th Amendment, then the federal government is going to stay out of our racial matters. So the whole concept of what you glean from this magnanimous effort in terms of, well, we're going to free citizenship, certainly wasn't anything they thought about on that nature. And that whole line of cases post-Reconstruction that leads up to it, the Supreme Court was doing its job. It was doing Marbury versus Madison, interpreting that constitutional amendment. Fortunately, there's been a reversal in terms of thought. I mean, we have now human trafficking clearly now within it, and other forms of involuntary servitude that the court has moved to say there is something more to the 13th Amendment other than just the freedom of African Americans in that instance. But then they were doing just what they wanted to do, and that's the way they interpreted it.
But they would do what they
Now
wanted
I
to
have
do.
to say, a good panel, like a good dinner party, is one that you don't want to end. And this is spectacular because you guys are really going at it. But Judge Donald, you're going to have the last word. I want to ask,
Yes.
were the courts following public opinion, subverting the amendments when after the Compromise of 1876, and then by the time of Brown, 54% of the country favors ending segregation? The courts follow. Were they following or leading?
What I was going to tell you is that so many times the court is really going to follow sort of the will of the people. And I think in this case, they were pretty much following that will when the will of the public was that we don't want this. If you look back through those cases, even though the courts were, some people say taking leadership, but that leadership really sort of mirrored the will of the people. And now in the third founding, courts stepped up, and Justice Scalia would say that they actually usurped the role of the legislature there. But courts actually took a leadership role, and there were some really giants who looked at the law and had fidelity to the law and really paved the way for us to really move forward. But there were times when the courts were part of the problem.
But that is an abdication of responsibility, right?
Yeah.
I mean, there's a case called Giles versus Harris from, 1911, where the Supreme Court says, even though, yes, we think Alabama's violating the law by not registering blacks to vote, there's no point in us issuing a ruling that says that because they're not going to follow us anyway.
And that's
an abdication of
It
responsibility.
is. It's an abdication of responsibility, and it's following the sort of the will of the people. There you go.
Beautiful.
I want to make one
You can
last
do it.
point.
It's-
I mean,
you
one
started
last
us
point.
off, and you can end it.
Because
Absolutely.
I don't want us to leave without connecting Black Lives Matter in its present form
Come on.
with Black Lives Matter with the 13th Amendment. Do you understand if the lives of black slaves did not matter, then those descended from them could not matter? I mean, you got to start with a foundational belief that lives mattered. And if you can begin, what we're doing now is a celebration of the abolition of slavery because Black Lives Matter, you then can import the meaning into a modern setting. But to start from the beginning is saying, well, all of a sudden it matters. All lives matter. And you got to have that kind of concept be implanted in the minds of the people rather than all of a sudden now it matters. And now we have a movement.
That is beautifully said. The only way I can bring myself to stop this panel on time is to make sure that we're going to reconvene over the next 5 years to keep this second founding discussion
Look forward
going.
to it.
Ladies and gentlemen, please join me in thanking our incredible panelists. Excellent. Beautiful. Very nice. and you see the value of bringing judges together, along with great litigators like Sherilyn, to talk about how they are human beings as well, and they are experiencing the same issues that the country is debating in their courtrooms, and the relationship between the law and public opinion and law and personal experience is one that we're really going to examine over the next 3 years. Welcome to our wonderful next group. And our final panelist is being mic'd. No, of course we will wait. The show couldn't begin. So glad you're here. And ladies and gentlemen, you have before you a group of superb historians and scholars. It's like sitting in the back room in class. Yes, come together.
It's not like church.
Exactly. So you were told to sit there, but it's better to be close. Let me introduce this amazing group and then jump right in. Thavolia Glymph is an associate professor at Duke University. She works in the African and African American Studies Department. She is the author of House of Bondage, The Transformation of the Plantation Household. And I'm going to ask her about that great book in a second. Richard Brookhiser is a journalist, biographer, and historian, senior editor of National Review, known for a series of biographies on America's founders, including the just published, and that's why I'm happy to wave it up here, and I think you can get it afterward if you like, as you should, because it's great. Founder's Son, A Life of American Lincoln. And Kate Masur is a professor at Northwestern University. She studies the history of the United States. She is the author of, and I'm going to wave this too, and Thavolia, Amazon didn't send it soon enough, but you've got, I'm waving Thavolia's as well in spirit. Kate Masur's book is An Example for All the Land, Emancipation and the Struggle Over Equality in Washington, D.C., and she is leading a really exciting project on behalf of the National Park Service to identify a permanent legacy to the constitutional achievements of Reconstruction. And we'll ask her just a bit about that. So please join me in welcoming all of our great panelists. Professor Masur, well, tell us about this great project. What are you trying to do?
The National Park Service project? Well, so the National Park Service, as probably everybody here knows, is an incredibly important force for the interpretation of history in the United States. It not only obviously superintends the great national parks that have to do with nature, like the Grand Canyon, but also almost all of the Civil War battlefields are National Park Service sites, for example, and a host of other different kinds of historic sites. And actually one of the kind of hallmarks of the Park Service in terms of history has been Civil War battlefields and the interpretation of the American Civil War. That fact notwithstanding, the Park Service has never until now had a site dedicated to the period of Reconstruction, nor has it had an interpretive framework for the study of Reconstruction for reasons that we could talk about for sure. And so in the last approximately 2 years, I and some other historians in universities, including Thavolia Glymph, and have partnered with people in the Park Service to begin to come up with a set of ways of beginning to grapple with the history of Reconstruction on behalf of the Park Service. And those have ranged from preliminary meetings in Washington to the creation of a handbook on Reconstruction, which is an illustrated collection of essays, which will be published any minute by well-known historians that kind of trace the current leading interpretations of Reconstruction, to a national historic landmark theme study, which my partner in this, Gregory Downs, who's a historian at UC Davis, and I are co-authoring, again with the help of a lot of Park Service staff. We're compiling information about existing sites all over the former Confederacy, which is where we're starting, at least for now, existing sites related to the study or related to the history of Reconstruction, and then we'll make recommendations about sites of particular significance. So it's a kind of ongoing process, and it's been terrifically exciting.
Wonderful. Thank you for sharing it and for doing it. It is tremendously exciting, and we're happy to be part of it with these kind of conversations. Richard Brookhiser, this book's been getting a lot of great reviews, and you make a provocative claim that Lincoln, far from simply rejecting the founders, Madison, Washington, and Jefferson, as slave owners, embraced them and made them part of his new birth of freedom. Tell us more about that provocative interpretation.
Well, Lincoln is a very careful writer and speaker. And if he'd meant to say a birth of new freedom, he would have done that. But he said a new birth of freedom. We talked in the first panel about the importance of the law in taking the lead in shaping people's consciousness, and certainly it's vital. But we wouldn't have had the 13th Amendment if 750,000 people hadn't been killed. I mean, the Civil War was the worst experience this country has ever had, and we wouldn't have stood it. We wouldn't have gone through that if enough people hadn't felt that what they were doing was somehow related to what America was. What it ought to be, but what it ought to be because of what it already was. That we were repairing a wound in our structure, but something that shouldn't have been there. Now, not everybody thought that. Obviously, the Confederates had their own different view. There were a lot of people in the North who didn't share that. But enough Americans, Lincoln being the spokesman and the leader of that group, felt that. And that's why they were willing to go through that experience. And then one of the crowns of it is the 13th Amendment, and then later the 14th and 15th.
Spectacular. Let me ask one follow-up question because it's the natural one, and I know the group will want to discuss. The very positive New York Times review said Brookhiser's Lincoln absolves the revolutionary generation of complicity with slavery. The founders had accepted slavery as Lincoln put it by necessity, and in connecting the founders to Lincoln, this is a portrait of the founding fathers, not as masters, which so many of them actually were, but as captives of slavery. What's your response?
Well, founding fathers, they're like our actual fathers, you know, and they're a mixed bag, just like everyone's actual father is a mixed bag. And, you know, there are bad qualities and there are good qualities, and you have to understand the bad ones, but you also look to the good ones and try to cling to those. And that's what Lincoln is doing. I mean, Lincoln has some very negative thoughts about Thomas Jefferson, for instance, but he didn't utter those in public. The Jefferson that he wanted to talk about was the young man who wrote the Declaration of Independence. You know, the older Jefferson who backslides and, you know, who goes all over the lot with his opinions about, you know, what we should do with racial matters. Lincoln suppresses him, but he focuses on something that's very real, which is the man who wrote the Declaration of Independence and never abandoned that belief. I mean, for all of Jefferson's backsliding, he never felt that all men were not created equal. I mean, to his death, he would have believed that.
And Lincoln famously said right in front of Independence Hall, 1861, I would rather be assassinated on this spot than abandon the principles of the Declaration of Independence.
Yeah, we waited 4 years to do that.
It's astonishing to pass Independence Hall and think of him saying that. Professor Glimpf, I want you to talk about your book, Out of the House of Bondage. You talk about the ways that black women took center stage along black men as claimants to power and privilege, but to white Americans, the freedom was the most unearned and their interpretation of it the most misguided. Tell us more about this fascinating and important thesis.
Well, I guess the best way to talk about the book, which I don't want to say much about, it's quite old project, and I'm working on something different now. But the main point of the book and my current work is that we can't talk about the 13th Amendment or the Emancipation Proclamation without talking about the people who were, in effect, the drivers of those amendments and the proclamation. And so what is often missing in our conversation is the slaves themselves. So we sit here and we talk about Lincoln, and we talk about the armies, and the armies were critical. Black people knew that where the armies were, they could go and perhaps claim refuge, but it was problematic. And we talk about Lincoln's struggle to get to the point where he could take on the freed people's or the slaves' agenda. So this agenda is their agenda. It's not the Union agenda, it's not the Confederate agenda, it's the slaves' agenda. And so they push it. And so finally Lincoln says, okay, in the preliminary Emancipation Proclamation, he says to black people, in effect, I see you, you're coming, I can't stop you, and so now I'm going to encourage you to come. And he does that again with the Emancipation Proclamation, and they keep coming by the hundreds of thousands. And so by 1865, you've got hundreds of thousands of people who were enslaved, who can't be remade into slaves, who are now free people by virtue of the First Confiscation Act, the Second Confiscation Act, the Article of War of 1862, the Emancipation Proclamation, the Congressional Measure of March 1865 that frees the women and the wives and children of black soldiers. And so I think we have to keep a clear understanding of this process, this back and forth that gets us to the passage of the 13th Amendment. And also, very importantly, that it's not that the House and the Senate, sat down and said, oh, okay, we're going to pass these amendments, but that it's a very long and drawn-out process. The House takes a long time to pass it, the Senate takes a while to pass it, and finally it goes to the states for ratification. And it's only after Lincoln, again, on the anniversary of a year before the amendment is passed, on December 6, 1864, when he makes his fourth annual message to Congress, he says, please, pass this bill. And he said, you're the same guys who didn't pass it before, but I'm begging you to please pass it now. And he only needed a few votes. And so this is not a period when people are just eagerly sort of applauding the work of freed people or slaves to get their freedom. And I think that's really important. And we're here in Washington, D.C., and Kate could probably say more about this, and she wrote a book about Washington, D.C. So some people said, well, if Congress, while we're debating this issue, where can we emancipate free people, and where can we also think about where black men could vote? D.C. So emancipation comes to D.C. early on in 62. And then in 65, they say, well, thinking about more than freedom, citizenship and the vote, well, let's test D.C. And what happens? The vast majority of white men who can vote in D.C. say, of course not. I think the vote was something like 35 to maybe 14,000 people who said no, and 35 who said okay. And so this is I just want to stress how important it is to talk about this entire matter as a process that was very difficult, and also to put black people on the page here, sort of alongside Lincoln and sort of pushing Lincoln.
That's a great way of framing it, and thank you in the spirit of Judge Wynn's homework assignment to focus on the 13th Amendment itself and the process by which it passed. I want to ask more about that process in a moment, but since you mentioned Professor Mazur's book about DC, and the book does indeed use DC as a sort of laboratory of democracy for emancipation, talking about the status of schools and voting and so forth, give us a sense of the highlights and how was emancipation a sort of dress rehearsal, in DC, a dress rehearsal for the 13th Amendment?
Well, part of what's so interesting about Washington is sort of the mirror image of the states. And part of why Washington, D.C. was so special during the Civil War and Reconstruction was precisely because it wasn't a state. And for all of the reasons, and I thought it was really terrific on the last panel, people talking about the importance of the enforcement clause, because the whole problem, and this is something I try to teach about a lot with my students, I mean, the whole problem, the kind of constitutional problem of slavery was that states were allowed to have slavery if they wanted and not have slavery if they didn't. And the sort of enormity of the innovation of the 13th Amendment was the ability of the federal government and the people of the United States to finally say, no, there's one, you know, there are a lot of things states can still do, but there's one thing you can't do if you're a state, and it's have slavery. And that is not only a magisterial kind of change in terms of abolishing slavery, but also it's an enormous change in terms of the relationship between the federal government and the states up until that point. So DC's history is totally different because Congress had more or less unchallenged power in the District of Columbia, as people who live here now are well aware. And so Congress didn't have to worry. Some Democrats argued that Congress wasn't allowed to abolish slavery in the District of Columbia either, but that was kind of a fringe position. So they didn't have to worry about federalism, and so they just went ahead and abolished slavery. Actually, a lot of people think Lincoln did it, but actually Congress passed an Emancipation Act in April 1862, which Lincoln then signed. And then for the next several measures going forward, whether it was voting rights for African American men, I mean, preeminently also the desegregation of streetcars in Washington happened by congressional law in 1865, the spring of 1865, before the 13th Amendment passed, as a result of African American activism and pressure on Congress, not least by some African Americans who actually worked in the Capitol building, who used their positions as workers to get access to have conversations with members of Congress, members of the Senate, and talk to them about what they cared about. And people like Charles Sumner then put those kind of measures out on the floor of the Senate. And I want to add one thing, because I think it often gets forgotten in these conversations. It's also relevant to Washington, that at this moment of enormous constitutional change, women's rights activists also said at that particular moment, you know, this is a moment of huge change, of remaking the kind of fundamental premises of the United States, and we think there should be universal suffrage, by which they meant equal suffrage for men and women alike. And so that too happened in Washington, D.C. Another, not that women were enfranchised, but there was a very, very vibrant, at times, biracial movement for women's suffrage in Washington, where they were using the same arguments. Look, Congress, you can do what you want in Washington. Why don't you make an experiment in women's voting rights as well? So it was really a laboratory for democracy, but at the same time, it was also a laboratory for disfranchisement. And by the early 1870s, a coalition of basically businessmen of various stripes, what different political persuasions had kind of managed to come together and gotten the ear of a changing Congress, a Congress that was no longer quite as committed to these sorts of reforms, and persuaded Congress to actually remove all voting rights from the District of Columbia. So instead of allowing there to be, which there had been for 6 or 7 years, of black and men voting together electorate, now Congress took away the right of all residents of the District of Columbia to vote on their own government, and that was the case until the late 1960s. So actually the kind of downward trajectory of democracy in Washington during Reconstruction had a huge lasting impact in terms of local government, all the way until the Civil Rights Movement.
Fascinating. Richard Brookhiser, Kate Mazur has described this dialogue between the president and Congress. What was Lincoln's expectation of the 13th Amendment? What sort of 13th Amendment did he want? What did he believe that it would achieve? And did he also think there would be subsequent amendments necessary to achieve full equality?
Well, what would Lincoln's Reconstruction policy have been is a chestnut that biographers and historians, they go back and forth over. One of the few public hints he gave after Appomattox, he gave a speech from the White House to a crowd that gathered on the lawn to celebrate the surrender of the main Confederate Army. And this was a prepared, carefully prepared speech. And he had already had a plan for the reconstruction of Louisiana. This was a state, much of which had been occupied by the Union very early in the Civil War. There were Loyalists, there were Unionists there, not opposed to slavery necessarily, but certainly opposed to secession. And some of these people had gotten together, enough of them to elect a government, and they wanted Louisiana to participate in Congress as it had before the war. And Lincoln had a plan to allow that to happen so long as they supported the Emancipation Proclamation and the 13th Amendment. There was no provision for blacks to vote in Louisiana. But Lincoln, he wrote a private letter to the governor, the would-be governor of Louisiana, suggesting that veterans and the very intelligent be allowed to vote. And then in this speech, after Appomattox, he says this in public. And this is the first time he has mentioned voting rights for freedmen. One of the people in the crowd was John Wilkes Booth. And he said, that means nigger citizenship. That's the last speech he'll ever give. And it was. Booth killed him 4 days later. But that was, Lincoln, Lincoln is very cunning. Lincoln is a politician. I mean, he's a great man, a great writer, and all the rest of it, but he's also a politician. And he's a very good one. He's a very cunning one. He never says anything that he doesn't want to say. He shows his cards very slowly. But in that speech, he was like showing another card. And one of his genius during the war was he kept himself at the center of the Republican Party, which was the majority party in Congress. And it had radicals who were out ahead of him, and it had very conservative people who were dragging along behind him, but he kept them, most of them, all in the same tent. I mean, they fought, of course, but he kept most of them in the same tent and kept them moving along. And I think that this is an example of where he wanted them all next to go.
Professor Glimp, tell us more about the politics of the 13th Amendment. You said that it was hard to get through Congress, which seems to have changed its mind a bunch of times. I guess we've all seen the movie. How accurate was it, and how did Lincoln get the 13th Amendment through Congress?
Well, I think, the movie essentially takes us up through the passage in the House, which is the moment that most Americans know about when Congress passed the amendment in January of '65. But if you're asking about the entire process, then we'd have to go back again, and I sound like a broken record, my students tell me. But we have to go back again to the enslaved people who are insisting on their freedom. And then we have to go to the abolitionists, both black and white, who say this is really important and who sign petitions that they carry to Congress, knowing that the 13th Amendment will have no constitutional foundation and that anything can happen. And so these petitions go to Congress, and the proposal is finally made for a 13th Amendment to the Constitution. And while we're sort of on the 13th Amendment again, to go back, many of you know, of course, that the original 13th Amendment was an amendment that went through Congress proposing that slavery be made constitutional. I mean, this is at a moment when there is great concern that this war that's about to happen it's not worth losing 750,000 lives over black people. And so Congress says, okay, we'll have an amendment that will ensure Southerners that they don't have anything to worry about. And so that's the first 13th Amendment. And so we get to the second 13th Amendment, which does finally get proposed and does finally get through the Senate and does finally get through the House. And then it goes through this long process of ratification. And it's not surprising that, when was it Mississippi finally ratified, Judge? 113 years after the amendment was passed. But,
Better late than never.
it's still, despite Mississippi's reticence, it's still the law. So that's just part of a difficult history, and I think it's very hard for any of us to sit here and summarize this very long, drawn-out process where people were making deals behind, in the back rooms and trying to figure out what was possible, which states would pass it. And Northerners, of course, had to realize that, okay, if we're going to go with freedom for all black people, and the next big question is going to be, as the panelists indicated before, what does freedom encompass? what is this bundle of rights? Does it encompass, most importantly, the right to vote? And Northerners had to say, well, okay, we're not totally there yet because Black people can't vote in every northern state. Americans had to deal with the fact that up to this point, the only real document that gave one or acknowledged one's citizenship was what? The passport. And Black people up through 1863 could barely get a passport. You got something called a protection paper. And if you wanted to travel abroad, and there were exceptions, a few Black people here and there got a passport. And finally, Lincoln's administration is the one where the Secretary of State says, okay, Black people can have passports. So there are a number of issues and questions and problems that arise around the 13th that lead us to the 14th and to the 15th. And the passport issue, if you I'm teaching a course this semester in the Duke Law School, and one of my students is writing this wonderful paper on these passports and on the tremendous energy that went into fighting this battle for citizenship long before the Civil War in the North, and that was covered almost every day by the Black newspapers, who say, finally, if you can't get a passport, that means you're not a citizen. And so these, we pay so much attention to Plessy that we forget about all of these other cases, including the ones that a wonderful historian, Martha Jones, is writing about, where Black people are fighting for citizenship long before the Civil War. So it's not just something that Congress and Lincoln decide, okay, to give us in 1863.
You remind us so importantly that the story of African Americans demanding the end of slavery is central, and also the question of what freedom encompassed is central. Professor Mazur, you wrote in your great contribution to the Atlantic Magazine's second founding symposium, which the Constitutional Accountability Center and the NCC were delighted to co-host. You said the 13th Amendment was the beginning, not the end of the effort to remake the nation, and you quoted Frederick Douglass. Slavery is not abolished until the Black man has the ballot. He went on to say, while the legislatures of the South retain the right to pass laws making any discrimination between Black and white, slavery still lives there. What was Douglass and other African-American leaders' response to the 13th Amendment? Did they think it didn't go far enough, and what do they think was necessary?
Well, absolutely. I think that quote from Douglass is from the spring of 1865, so it would have been around the time that the Senate passed the 13th Amendment, it was after the amendment had passed. But they, there's a really significant convention of African American men in Syracuse, New York in 1864, in the summer of 1864, and it's, as Savolia was saying, there's a long history that we don't want to sort of write out of this, of African Americans, particularly in the North where they had more liberty, organizing, mobilizing for both their own rights and their own kind of well-being and dignity in the places where slavery had already been abolished, and also fighting to get slavery abolished in the South. And out of that came, from the 1830s through the 1860s and onward, an African-American convention movement. And one of the most significant conventions they had, and the most fascinating, was in 1864 when people met in Syracuse. And for the first time, a lot of Southerners were able to attend because the war had progressed enough, and enough people had been able to escape from slavery that people were able to travel from the slaveholding states into New York State to go to this convention. And they created a document that included a declaration of their views on what should happen next. And again, this is in 1864, and there were a lot of things they wanted to see happen, including respect, racially equal rights, dignity, decent labor conditions, and also the right to vote. And really, the right to vote and protection for the right to vote was on the agenda of African Americans, of course, in the North before the Civil War, in places like Pennsylvania, where they had been able to vote until the 1830s when the vote was taken away. in places like Illinois where they had never been able to vote. So it was on the agenda kind of nationally, but one of the most significant, I mean, we can sort of think about it as a different kind of significance or a different level of significance when you think about the emancipation of some 4 million people in the South, really being able to dramatically reshape the balance of power in the United States if they were enfranchised, and also on the local level to be able to control or to have a say in their own well-being in the kind of elected officials on the very most local level, sheriffs, tax assessors, just the people who you kind of interact with most on a daily level. And so the vote became this incredibly important thing. And well before, I mean, it wasn't like people passed the 13th Amendment and then turned their attention to the vote. You find so from Syracuse, the Syracuse Convention and onward, both Northern African Americans, freedmen, freed slaves in the South, organizing in state conventions to say, look, we cannot be free if we can't vote. And so it emerged immediately onto the agenda. It had already been on the agenda, but you can see it immediately even before the war ended.
Yeah, and I'd just like to add that quote that Douglass quote. Douglass, when he said freedom, will not have freedom until the black man has to vote. I mean, the context for that is also suggestions that the American Anti-Slavery Society should be closed down. And that the fight was done. And Douglass said, no, the fight is not done. And so that's the main context in which he kind of forces the abolitionists to keep this organization going because it's not over yet.
I think one. I'm sorry.
I just want to add one thing. I mean, because one of the things I really did want to say is that that this is the way, and this kind of trajectory and the ways that, we think of the Civil War as having ended in the spring of 1865, but we can't understand the Civil War if we don't understand Reconstruction. We cannot end the story in April 1865 with the surrender at Appomattox and sort of go home content that we understood the implications of the Civil War. It's one big story from the beginning of the war until decades, kind of almost to the end of the 19th century, you could argue. So I feel like if one of the things that kind of can come out of this is a notion that that when we commemorate the history of this period, this completely fundamental period in American life, we can't tie up a nice little bow at the end of what we consider the end of the Civil War and think we understand it.
Great.
And-
Richard,
and
some thoughts from you, and then I'm going to we have a few minutes for questions for the audience, so please start thinking of them. Richard.
And the Reconstruction amendments were gelded by terrorism. That's what put the kibosh on it, which killed the Republican Party in the South. I mean, literally killed a lot of its members, white and black, terrorized the rest. The insurgents won. That was the story of Reconstruction.
Questions from the audience? We have mics, and if you could walk up to them, I think there's one over there and one over here.
Do the judges get to answer questions?
And I'm a law professor, so I can call on people. If they're,
We said everything.
here we go, great.
Hi, I'm not a law professor, so.
That's good.
But during the discussion, Professor Glimpf talked about the importance of not just focusing on the 13th Amendment, but what happened before and since and everything. So my question is, during the Civil War, you kind of mentioned, Professor Glimpf, a little bit. At what point did the political process sort of tilt away from trying to entrench slavery with the first 13th Amendment to the actual 13th Amendment that abolished it? Was there a certain point where politicians said, okay, let's put that one away. We're not going to be able to entrench it. Let's go the other way.
Good question. Professor Glimpf.
I'd say there's no defining moment, but I would say also that by the time we move into 1863, in terms of the war itself, and the issuance of the Emancipation Proclamation on January 1 of 1863, I think there's been a really significant shift. And that shift, to go back to my perennial point, that shift is marked in two ways. One, by the ability of the Union armies to do their job, okay? So who's going to win this war on the ground, on the battlefront? And once the Mississippi River is clear, and that's clear by April of 1863, that allows the Western armies to come east to help out those on the Eastern Front. So it's that spring of 1863 that to me is really important, because what the Emancipation Proclamation also does is that it says that the Union armies can enlist black men. And so the Western armies then benefit immensely from the effort to enlist black men from Mississippi and Alabama and Louisiana and so forth. So that's a critical turning point. And what do you do at that moment? Once you've enlisted black men, you can't go back and say, well, you're not going to be free. And then you have their wives and children who are saying, well, our husbands are in your camps and we deserve to be given refuge, to be given protection. And so they're moving to Union lines. I think the turning point is really the spring and summer of 1863. And I'm sure that if you talk to any military historian, they give you 10 other turning points.
But black men not only affect the military equation by their numbers in the Union forces, but then they also help change people's opinions. Because
Right.
this is the most important test of citizenship, or one of them. You fight
Right.
for your country.
Right.
And here are thousands and thousands of black men fighting alongside,
Exactly.
the white soldiers for the Union.
And proving that they
and
can,
impressing.
proving that, they can take a bullet, which is not something we, want to say we're proud to do, right? But that's the only way that you
can
can.
they can fire them.
Right.
Wonderful exchange. Yes, ma'am.
Hello, my name is Laverne Tuckson. I'm not an attorney or lawyer. I'm a scientist, really.
That's great.
And I really am thankful that this sort of event is taking place. And generally, I had a great sigh of relief when I heard the judge talk about his experience growing up and not in the history lessons and his history courses, and how so much of this, of what we're talking about today, just wasn't talked about earlier. So in saying all of that and listening to everyone speak, I hear terms of African American, but I don't hear the term colored. So when you say, or the term Negro, so when you use the word African American, I think about how we are today in this era of freedom, I guess you could call it. But when you talk about the Negro, I would like to hear that word Negro used as a term that could maybe validate the level of freedom that the person of African descent had. So when you use that word African American to talk about the history and the people who were enslaved in 1865, it's kind of conflicting or confusing or maybe not congruent. Just what do you think about that?
Interesting question. Who would like to take that?
Yeah, well, it's not historical. I mean, the people at the time are mostly, as you say, they're using Negro.
So should we use that word Negro when we talk about?
You have to remember that black newspapers are called the Afro blah, 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 or the African American. It's Afro-American and African American are not 20th century terms solely. People, you would almost never see a black newspaper in the North in 1850 called a Negro whatever. It's always the Afro something. So there was always to me, a really important effort on the part of people of African descent in this country to remember, right, to keep connected to slavery, which was through remembering the African part. Mm-hmm. And so I think it's easy, because our history is so washed away, to not know or for us to forget that these were terms that black people did indeed use in the 19th and the 18th century.
But one of the false solutions was colonization, which was, I mean, and even some people, a lot of people who opposed slavery thought, well, we'll free all the slaves, but we'll send them to Liberia. You know, we'll just get rid of them. And Lincoln seems to have believed this. I mean, as late as the early Civil War. But he, you know, he learns. The first delegation of black men who are admitted to the White House as, you know, people coming to talk to the president, you know, as peers. I mean, in a dialogue, are a group of black men from Washington, D.C., and Lincoln is pitching a colonization plan to them. And not Africa, but Panama, actually. And he gets no takers. I mean, he's like an auctioneer. He's saying, if I can get 100, if I can get 50, if I can get 25, you know, and they don't want to go. They're Americans. You know, why should we be sent someplace?
But
so
Congress
Lincoln
does.
learns from that.
He
Lincoln
does,
learns
but
from
Congress
that.
doesn't, right?
Well,
because
you know,
Congress
other
does
people-
appropriate the money, and we do send people off, and it's such a horrible
And it's a
experience. We have to
disaster.
go
It's a
send a
disaster.
warship to bring them back.
That's right. Well, that's right. And so, I mean, Lincoln maybe learned ahead of some other people, but,
Yeah.
but a lot of people were learning from
Right.
this.
Well, thank you for your comment. That was just a developing thought that came across as I was listening to the panelists speak
Thank you.
and
Can I-
and the interchanging of
Thank you
those
for that.
terms.
It's a great question. My only job as a moderator is to end on time, and we have 1 minute left, and you have the last word.
Oh, I just had a thought about that, which is that you were pointing to an important question that I think is hard to grapple with, because we are writing in the present and talking in the present about the terms people of African descent in the United States have talked a lot about what they want to be called, right? And there have been a variety of different terms. And you see, you know, in the period that we're talking about, colored, you see people discussing it as, and it's very, very important, as it is today, for people to think about it, this idea of naming. And so when we're talking about it, I mean, there's another conversation about whether to call people slaves who were enslaved. Is it okay to say, well, they were a slave, or should you call them an enslaved person, because it sort of dignifies the person and doesn't reduce them to enslavement? And I think that, you know, the question is a very sensitive one, because it's about this kind of problem of talking about the past in the context of this complicated history of terminology.
Well, maybe
Lady-
this is the time it could be desensitized and it could be, you know, repurposed.
This whole conversation has been a great contribution to precisely that sort of civil discourse. Ladies and gentlemen, this is an incredibly auspicious commemoration of our anniversary. Join us. Amtrak is a short ride. Wait, 1 sec. I can assure you from personal experience that the train ride to Philly is pleasant. And on Wednesday evening, we're going to continue this great series with Richard Brookhiser, who will be moderating a conversation with Eric Foner, the great Reconstruction historian, at the National Constitution Center, co-sponsored by the Constitutional Accountability Center and the NCC. Please join us for the next 5 years for the second founding initiative, and thank our great panelists. Excellent.